Good morning, everyone. This is a mic check. As a kind reminder to those in the room, if you are speaking today, please make sure that you are within a few inches of the microphone to be heard loud and clear, and also make sure that the light is on before you begin speaking. When you leave the podium, please make sure to mute the microphone as I'm about to do right now.
Good morning and welcome to the January 14th, 2026 meeting of the Texas Commission on Environmental Quality. The time is 9:35 a.m. For the record, I'm Chairwoman Brooke Popp, and with me today is Commissioner Katarina Gonzalez, our General Counsel Mary Smith, and our Public Interest Counsel Garrett Arthur. For each item that argument and discussion is allowed, we'll inform parties and the public of time limits for their discussion. The registration closed at 9:30, but if you'd like to address the Commission on a particular item, please either visit the registration table, or if you're online, hop on the internet and email agenda.tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our absolute best to accommodate you. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking, and please, please, please make sure your line is unmuted before proceeding. With that, Mary, you want to call the first item?
The first item is the consideration of the ALJ's proposal for decision and proposed order concerning the application by LVDP Holdings, LLC for new TIPD's permit number WQ00159640001. The parties have been notified that the applicant, the protestants collectively, the ED, and OPIC will each have 5 minutes for oral argument, and they will speak in that order. The applicant may save time for rebuttal as it bears the burden of proof on this application. So with that, we'll begin with the applicant, and I believe we have Mr. Moore here.
Good morning.
Good morning, Chairwoman. Good morning, Commissioner, General Counsel. I'm Brian Moore. I'm with the law firm of Coates Rose, and we represent the applicant in this matter. The ALJ's PFD recommends permit issuance, and not surprisingly, we support that recommendation. And we appreciate the ALJ's time and the Executive Director's time reviewing the application and considering and weighing the evidence. The parties, in this case, fully briefed their arguments, and then we briefed them again, and some even briefed them yet again in their exceptions to the ALJ's PFD. And I fully expect that you're going to hear those very same arguments again today, again this morning. But you're not going to hear them from me. You're not going to hear them from the applicant, at least not right now. You've studied the record. You've reviewed the briefs and the ALJ's PFD. And if you have any questions, I trust that you will not hesitate to ask them. So I thank you for your time, and I'll reserve the rest of mine for rebuttal and take any questions that you may have.
Thank you very much. Appreciate you. All right. Hear from the protestants.
Yes, and I believe we have Mr. McWhorter first.
Good morning.
Good morning. I'm Vic McWhorter with the firm Perales, Allman and Ice. We represent Texans for mud reform. Based on the record, the proposed permit should be denied both on water quality and regionalization grounds. Regarding water quality, TMR members rely on the attainment of high aquatic life uses in the receiving waters downstream of the proposed discharge. TMR members catch and eat fish from these waters. They also enjoy the abundant wildlife supported by these waters, which include geese, herons, egrets, and ducks. The modeling presented in support of the permit is flawed and based on false assumptions. It fails to demonstrate that high-quality aquatic life uses are adequately protected. We think it's also important to note that downstream waters often inundate neighboring property. When this happens, standing water remains on the site of those properties for extended periods of time. For example, TMR member Callie Taylor's property was underwater for a month on at least 2 occasions in 2018 and 2021. Such inundation events would result in an elevated risk of contamination exposure to neighbors if the permit is granted. The record simply does not show that the permit is adequately protective. Regarding regionalization, the Water Code requires the use of all reasonable methods to promote the development of area-wide wastewater systems. A flurry of development in Ellis County has led to numerous individual applications, including the one before you, and highlights the need for due consideration of the state's statutory mandate to promote regionalization. Here, the record shows the city of Waxahachie was not provided with a request for service containing sufficient information that would allow the city to evaluate the circumstances and respond. In summary, the application should be denied because of the failure to demonstrate compliance with regionalization requirements and the failure to show the existing high aquatic life uses would be adequately protected. And the remainder of protestants' time, I believe, will be used by Ellis County and the city of Waxahachie.
Thank you very much. Oh, yes.
I have some questions.
Can you come back up, please?
Yes, ma'am.
Thanks. I haven't heard of Texans for Mud Reform. Could you tell us a little bit about that?
Yes, it's a group of citizens in Ellis County that have a lot of interest in the environmental issues that are happening around there, and it's been granted party status in a few different cases involving that area.
Okay, it's new, so curious. Thank you.
Sure.
Thank you. Ms. Albright?
Good morning, Commissioners. My name is Stephanie Albright, and I'm with Bickerstaff, Heath, Delgado, Acosta, and I represent Ellis County and the city of Waxahachie in this matter. First, I want to address the larger issue of why that the county and the city are protesting this application that's before you now. The reason for this is just what's noticed in the discharge route. Under the proposed permit, 1.2 million gallons per day of treated wastewater will flow into the discharge route and ultimately into Bardwell Reservoir. This is a primary drinking water source of the area, with each new permit authorized by this commission, more treated wastewater is being discharged into the regional drinking water source of the citizens that live in Ellis County. The county and the city have an interest in ensuring that water quality is protected to the maximum amount that is acceptable, and both through the permit limits and the regionalization, they're looking to limiting the pollutants that go into their drinking water. So first, the draft permit is not protective of water quality and does not adequately address total phosphorus. Nitrate, nitrogen, and total phosphorus increase algae proliferation in the receiving waters, and especially in situations during dry periods, which unfortunately is common in Texas. The total phosphorus limit contained in the draft permit is high enough, and the county and the city have shown that it would provide a steady source of nutrients to support algal growth in the receiving waters. Algae was not taken into account in any modeling that was related to the draft permit, and this increased proliferation of algae would cause situations relating to dissolved oxygen that would be loading up the pollutants and loading up the phosphorus that would eventually go into Lake Bardwell. Additionally, the application did not comply with the state's regionalization policy. The Texas legislature has directed the TCEQ to observe the regionalization policy in Chapter 26 of the Texas Water Code. And TCEQ has the authority to deny wastewater applications where there are existing and available regional wastewater system. In this matter, the county and the city have provided evidence showing that the city of Waxahachie's existing wastewater collection system is approximately 2.6 miles from the proposed wastewater treatment plant. The city testified that it does have the wastewater capacity to serve the proposed development, and that the city is willing to serve the proposed development. As I stated in the beginning of my comments, regionalization is beneficial to water quality, and it provides both operational and water quality benefits. Instead of numerous small wastewater systems, such as the one that's being proposed now, systems that have the potential for operational and water. Thank you. And we recommend denial of the permit.
Thank you, Ms. Albright.
Thanks.
So we have the ED.
Good morning, Chairwoman, Commissioners. General Counsel, Public Interest Counsel. For the record, I am Michael Parr of the Environmental Law Division, here representing the ED. With me today is Abdur Rahim and Peter Schaefer of the Water Quality Division. The ED agrees with the ALJ's conclusions and findings as referenced in her PFD and order. The ALJ, the Honorable Rebecca Smith, after considering the pleadings, evidence, arguments on the issues referred to SOA by the Commission, found that the application should be granted. The ALJ found that no party tendered any evidence to rebut the prima facie presumption that the draft permit meets all applicable legal and technical requirements. Am I not talking close enough?
No, you're fine.
Okay.
Yep.
More specifically, the ALJ found that the uncontroverted evidence in the record established that the draft permit is protective of water quality in accordance with the Texas Surface Water Quality Standards, and that the application also meets the implementation requirements for the state's regionalization policy. The ED recommends adoption of the ALJ's PFD in order, and the draft permit be issued with the changes memorialized in the ALJ's December 5th exceptions letter. Thank you. We are available for any questions.
Michael, I do have one question for y'all. Ms. Albright touched upon an argument that algae wasn't taken into consideration within the modeling. Can you touch upon that? Someone from the ED staff?
Actually, I think since this is a PFD and it should be based on the information in the record, it would I'd just like to caution everybody that all of this information shouldn't be expanded upon. It should be based on what's in the record.
Would you walk us through the modeling?
Sure, yeah. My name is Peter Schaefer. I'm the team leader of the standards implementation team here at the Water Quality Division. They mentioned water quality modeling. There was no modeling per se that was done, but there was an analysis, a screening done in accordance with our implementation procedures. So we have established screening procedures for nutrients, and those procedures were followed in this case, which resulted in the total phosphorus limit that was recommended and put into the draft permit.
Excellent. Thank you very much. Do you have any follow-up questions? Or nope. All right. Thank you. We'll hear from OPIC, please.
Hi. Good morning, Chairwoman, Commissioner, General Counsel, and the Executive Director's Attorney and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. With respect to the Commission's consideration of the proposal for decision and related record in this matter, after participating in the hearing on the merits and examining the evidence and argument presented, OPIC maintains the position taken in our closing brief, that the application and draft permit meet all applicable statutory and regulatory requirements, and thus the draft permit should be issued. We found that the applicant met its burden of proof on both of the issues referred by the Commission for consideration at the hearing. With regard to the contested issue of water quality and its related issue of dissolved oxygen, OPIC found that the deficiencies alleged by the protestants were adequately addressed by the Executive Director, and that the final draft permit has been demonstrated to be protective of water quality. For instance, OPIC found dispositive that while one of the protestants' experts criticized the site-specific hydraulic coefficients used to model part of the discharge route, he was unaware that the Executive Director performed additional modeling using the default coefficients that he had suggested. This updated modeling confirmed that the originally recommended effluent limitations are adequate to maintain the dissolved oxygen levels above their applicable criteria. OPIC also found that the protestants' contentions regarding the proliferation of algae to be similarly unconvincing. Protestants' concern that the unnamed reservoir's phosphorus content could exceed the draft permit's limit during dry periods was only informed by their experts' best professional judgment and was not the result of mass balance calculations or independent modeling. Further, protestants' prediction did not take into account the loss of phosphorus through degradation and sedimentation. Finally, with respect to the issue of regionalization, OPIC found that the applicant complied with the state's regionalization policy. Ample evidence in the record demonstrates that the city of Waxahachie effectively denied the applicant's request for sewer service. Under the facts of this case, this denial marked the completion of the regionalization analysis. Therefore, After consideration of the record in this matter, OPIC finds that the preponderance of evidence demonstrates that the applicant has carried its burden of proof on this application. As such, we respectfully recommend adopting the proposal for decision, incorporating the limited changes recommended in the ALJ's exceptions letter, and issuing the final draft permit consistent with that proposal for decision. Thank you, and I'm available for any questions.
Thank you, Sheldon. Appreciate it. Mr. Moore, I believe that you have 3 minutes and 37 seconds remaining. Should you decide to take them?
And I'll decide not to take all of it. Any remarks that I could offer have already been covered aptly by the Executive Director's Council and OPIC's Council, and I appreciate their remarks. And again, stand for any questions you may have.
Thank you. Anything? Yep. All right. Well, before us is a PFD concerning an application by LVTP Holdings for a TIPD's permit to authorize a new wastewater treatment facility in Ellis County. I've reviewed the record in the ALJ's analysis and recommendation to grant the TIPD's permit. In my evaluation, I find that the evidence in the record supports the ALJ's determination that the applicant met its burden to establish that the draft permit is protective and meets all applicable requirements. So I would adopt the ALJ's proposed order with the corrections agreed to by the ALJ in her October 23, 2025 reply to exceptions. In addition, it appears that the draft permit effluent limit for ammonia and nitrogen was inadvertently omitted from the proposed order. Therefore, finding of fact number 8 should be revised to include the draft permit ammonia and nitrogen limits of 1.2 milligrams per liter in the interim phase and 1.1 milligrams per liter in the final phase. But before I fully propose that, I would like to ask the party representatives if they have any objections to this proposed change.
No objection from the ED.
No objection from OPIC.
And none from the applicant. Thank you.
All right. I move that we adopt the ALJ's proposed order with the following clerical and clarifying changes. On page 1 of the proposed order and in the caption, replace LVTP Holdings LLP with LVTP Holdings LLC. In finding of fact number 22, replace April 10th, 2025 with April 24th, 2025. And revise the finding of fact number 8 to include the draft permit ammonia nitrogen limits of 1.2 milligrams per liter in the interim phase and 1.1 milligrams per liter in the final phase. 2, issue the draft permit as recommended by the Executive Director. And 3, adopt the ED's response to comments.
Second.
All those in favor say aye.
Aye.
All right. Thank you. Motion passes. We will move on to item number 2. I think everyone has cedar fever today. I do.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Harris County Municipal Utility District number 531 for new TIPD's permit number WQ0016334001. The parties have been notified that the applicant, the protestants, collectively the ED, and OPIC will each have 5 minutes of oral argument time and will speak in that order. The applicant may reserve a portion of its time for rebuttal as the applicant bears the burden of proof in this matter. With that, we'll begin with the applicant, and I believe we have Mr. Worrell here.
Good morning.
Good morning, Chairwoman Pop, Commissioner, General Counsel, Public Interest Counsel. My name is Danny Worrell. I'm with the law firm of Baker Botts, and we represent the applicant, Harris County MUD number 531. And first, let me say that the applicant, not surprisingly, agrees with Judge Stobner's PFD as she had recommended in response to our exceptions to approve the application and to issue the permit. We believe that the law is clear for a contested case hearing on a TPDS permit such as this. The filing of the administrative record creates a prima facie demonstration that the draft permit meets all state and federal legal and technical requirements and is sufficiently protective of human health and safety, the environment, and physical property. In addition, protestant parties may rebut this presumption with the presentation of relevant evidence. The applicant in this case submitted the administrative record into evidence and established this prima facie demonstration that the application and the ED's draft permit meet all applicable legal and technical requirements, including the protectiveness requirements. Protestants did not rebut this presumption. Instead, they identified only irrelevant potential evidence related to issues that TCEQ did not refer to SOA and are not within TCEQ's jurisdiction, such as property value impacts and preferred other locations for applicants' wastewater treatment facility. In addition, OPEC also did not present evidence to rebut the presumption. Accordingly, the prima facie demonstration remains in place, unchallenged, and there are no genuine issues of material fact remaining. Recognizing this, the ALJ properly granted applicants' motion for summary disposition and issued a PFD on summary disposition. Further, neither OPIC nor the ED have raised objections either to the applicant's motion for summary disposition, to Judge Stogner's order granting the motion, or to the judge's PFD. Accordingly, applicant respectfully requests that the commissioners issue a final order approving the application and issuing the draft permit. Thank you, and I stand for questions, and I reserve the balance of my time for rebuttal.
Thank you, Mr. Worrell. Do you have any questions? Or? Nope. All right. We'll hear from the protestants.
And currently, no protestants have registered, but we can just give a moment to see if anyone comes forward.
Okay. All right. We will hear from the ED. Michael, you're up.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. For the record, I am Michael Parr with the Environmental Law Division. With me today is John Hearn of the Water Quality Division and Peter Schaefer, also of the Water Quality Division. The ED agrees with the Administrative Law Judge's conclusions and findings as referenced in her PFD. The Honorable Judge Stogner found that no party presented any evidence to rebut the prima facie demonstration that the draft permit meets all applicable regulations and is protective of human health and property. There was no evidence in the record that controverted any of the ED's evidence, so therefore the ED agrees with the PFD and recommends issuance of the permit. Thank you. We're available for questions.
Thank you, Michael. Any questions for the ED? All right, OPIC.
Good morning. Good morning, Chairwoman, Commissioner, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. In this matter, the ALJ granted applicant's motion for summary disposition and recommended that the draft permit be issued. OPIC is in agreement with the ALJ's recommendation. The Commission referred two issues: one, whether the draft permit is protective of wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards, and two, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13E. In accordance with 30 Texas Administrative Code, Section 80.137C, summary disposition of a contested case shall be rendered if it is shown that there is no genuine issue as to any material fact. The applicant presented uncontested summary disposition evidence establishing the draft permit's compliance with the Texas Surface Water Quality Standards and the Commission rules as they relate to nuisance odor controls. After the administrative record was admitted and established the prima facie demonstration, protestants had a burden of production to demonstrate that one or more provisions in the draft permit violate a specifically applicable state or federal requirement in accordance with Texas Government Code Section 2003.047 I-22. Protestants failed to present evidence to rebut the prima facie demonstration, and while their response references wastewater treatment facilities' potential economic, health, and nuisance harms, they failed to provide any testimonial or other evidence in support of their positions. Given protestants' failure to present any evidence to controvert or rebut the prima facie presumption that the draft permit meets all applicable legal and technical requirements and, if issued, would be protective of public and environmental health and safety and physical property, the ALJ found no genuine issue as to any material fact, including the two issues referred to the State Office of Administrative Hearings. For these reasons, OPIC agrees with the ALJ's recommendation that the Commission adopt the proposal for decision with the changes recommended in the ALJ's reply to exceptions letter and issue the draft permit. Thank you, and we are available for any questions.
Thank you, Jessica. Appreciate it. Mr. Worrell, you have 2 minutes and 10 seconds remaining. Thank you. Well, Commissioner Gonzalez, I've reviewed the record and the ALJ's PFD and the proposed order and agree with her recommendation, including the minor changes she's agreed to in a reply to exceptions letter. The evidence supports the ALJ's recommendation to grant the applicant's motion for summary disposition in this matter, as well as the issuance of the permit. Since the order does not expressly reference permit issuance, we may want to clarify that in the first ordering provision, which is consistent with the previous orders. I would also adopt the ED's response to comment. What are your thoughts?
I'm in agreement.
Wonderful. Do I have a motion?
I move that we adopt the administrative law judge's proposed order with the revisions recommended in the ALJ's reply to exceptions letter dated November 10, 2025, and the addition of, and the permit shall be issued to the end of ordering provision 1 for clarification. That we issue the draft permit as recommended by the executive director, and that we adopt the ED's response to comments.
All those in favor say aye.
Aye.
The motion passes.
And I guess we'll take it that you seconded that as well.
Do you want me to do it over again?
No,
Okay.
I think we're good.
All right, let's move on to item 3, please.
Item number 3 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Waste Connections Lone Star Incorporated for municipal solid waste permit number 2420. The parties have been notified that the applicant, the protestants, the ED, and OPIC will each have 5 minutes of oral argument time and will speak in that order. The applicant may reserve a portion of its time for rebuttal as the applicant bears the burden of proof in this matter. And I believe we have Mr. Moore for the applicant.
Welcome back, Mr. Moore.
Thank you for having me back. And once again, good morning. Once again, for the record, I'm Brian Moore with the law firm of Coates Rose. And once again, we represent the applicant in this matter, Waste Connections Lone Star, Inc. Commissioners, this matter is different from the last matter that I just appeared before you on. In that, in this case, we admitted the administrative record at the preliminary hearing and then proceeded to reach a settlement with every single protestant in the case except one. And that lone protestant who elected not to settle then elected not to participate in the case. Didn't respond to discovery, didn't file pre-filed testimony, just simply didn't show up. So we filed a motion for summary disposition, which of course was granted, and which led to the PFD, which of course we support. So with that context, I'll reserve the rest of my time. In the event that there is anything to rebut, I don't expect that there will be, but thank you. I appreciate it.
Thank you very much. Protestants?
Currently, again, no one is registered to speak for the protestants. So I think you're good to go on to
Right.
the ED.
We'll move on to the executive director.
Good morning, Chairwoman, Commissioner, General Counsel, and Office of Public Interest Counsel. My name is Nick Pilcher. I'm a staff attorney with the Environmental Law Division. With me today is Mamadou Balde with the Waste Permits Division. We're here on behalf of the Executive Director. The Executive Director supports the Administrative Law Judge's proposal for decision and proposed order with the modifications stated in applicant's exceptions, and respectfully recommends that the Commission issue an order approving the permit application and issuance of the draft permit. We're available if you have any questions. Thank you.
Thank you. Appreciate it. OPIC.
Good morning, Chairwoman and Commissioner. For the record, I am Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports this proposal for decision and the ALJ's recommendation to issue the permit. The record shows that none of the protestants filed any testimony or exhibits by the August 4th, 2025 deadline. Accordingly, OPIC finds that the ALJ properly granted applicant's motion for summary disposition because no evidence was presented by protestants to rebut the prima facie demonstration. No party presented any evidence to rebut the prima facie presumption that the draft permit meets all applicable legal and technical requirements and, if issued, would be protective of human health and safety, the environment, and physical property. Therefore, OPIC also agrees with the ALJ's finding that there is no genuine issue as to any material fact. For these reasons, OPIC respectfully recommends that the Commission adopt the proposal for decision, including the recommended changes addressed in the ALJ's exceptions letter, and issue the permit. Thank you.
Thank you very much. Mr. Moore, you have 3 minutes and 59 seconds left, should you decide to use them.
And just enough time to say thank you again for your time and consideration of this matter.
Thank you. Appreciate it. All right. Item number 3 requires us to consider that the PFD concerning the application by Waste Connections Lone Star Inc. for a new municipal solid waste transfer station in Bexar County. After reviewing the administrative record, I agree with the ALJ that the application meets all legal and technical requirements, and the draft permit would be protective of public health and safety, the environment, and physical property. I also agree with the ALJ that no party presented evidence to rebut the prima facie demonstration. So I'd adopt the ALJ's proposed order with the changes she noted in her December 5th, 2025 exceptions letter. I also noticed 4 additional clerical changes that I would make to the proposed order. First, in finding of fact 14, I propose that we change January 21st to January 28th to accurately reflect the conclusion of the public comment period. In conclusion of law number 3, I propose that we add notice citations specific to municipal solid waste from Chapter 361, Texas Health and Safety Code. Finally, in conclusion of law number 4, I propose correcting the spelling of government. And in ordering provision 1, I propose adding language to make clear that TCEQ shall issue the MSW permit. I've also reviewed the ED's response to comments and propose that we adopt it to the extent it's consistent with the Commission's decision on this application. Katerina, any thoughts?
I'm in agreement.
All right. I move that we adopt the ALJ's proposed order as revised by the ALJ's letter regarding the exceptions dated December 5th, 2025, and with the following changes. A, in finding of fact 14, change January 21st to January 28th to accurately reflect the conclusion of the public comment period. In conclusion of law 3, add citations to Texas Health and Safety Codes, section 361.0665 and 361.081. In conclusion of law 4, correct the spelling of government. And D, in ordering provision 1, add and the permit shall be issued. Issue the ED's draft permit and adopt the ED's response to comments to the extent that it is consistent with the Commission's decision on this application.
A second?
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. We'll move on to item 4. Let everyone shuffle.
Item number 4 is the consideration of the application by PHHOU Benton Road 200 LLC for new TIPD's permit number WQ 00165700001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, before us, we have an application for a new TIPD's permit that would authorize the discharge of treated domestic wastewater at an average flow not to exceed 200,000 gallons per day. The commission received 2 timely hearing requests from a Ms. Lily Wang. When considering the hearing request for these types of applications, the commission considers a 2-step analysis. First, we must determine whether a hearing requester is an affected person. And second, we determine whether an affected person raised issues in their hearing requests that are referable to SOA. Let's talk about affectedness. To be considered an affected person, a requester must explain how they'll be affected by the application in a manner that is not common to members of the general public. The hearing requester must also file timely comments in a hearing request that identifies their personal interest and the concerns that they have. The identified concerns must be within the commission's jurisdiction to address in the authorization. I agree with the ED and OPIC that Ms. Lily Wang has demonstrated that she is an affected person. Given her close proximity to the proposed facility and her concern about the personal impact of the nuisance odors raised in her request, I believe that Ms. Wang has shown that she may be personally affected by this application in a manner that is not common to the general public. I'll stop there and see where you landed on effectiveness, Commissioner Gonzalez.
I agree. She's pretty close to the facility and did raise some issues in her comments of concern.
Thank you. Let's move on to the issues. Moving on to the second part of our analysis, Ms. Wang raised a relevant and material issue regarding nuisance odor. This issue is within our jurisdiction to consider for a TIPD's permit, so I would recommend that we send this issue to SOA. I do not recommend referring an issue regarding health impacts from the wastewater discharge because it was not adequately raised by Ms. Wang in either of her timely hearing requests. Finally, given the single protestant and the nature of the single issue, I would propose a 150 hearing day duration. Katarina, do you have any thoughts?
I think that's a good idea.
Okay. Do I have a motion?
I move that we grant the timely hearing request of Lily Wang and deny all other hearing requests, that we refer the application to SOA for contested case hearing on the following issue: whether the draft permit adequately protects against nuisance odors in accordance with 30 TAC 309.13, and that we set a maximum hearing duration of 150 days from the date of the preliminary hearing until the proposal for decision is issued.
I second. All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Right. We will move on to item number 5.
Item number 5 is the consideration of gifts and donations of $500 or more in value given to the TCEQ. This is submitted for approval in accordance with the Texas Government Code, Chapter 575. The Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days in accordance with Chapter 575 of the Government Code. The Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. I'm available to answer any questions you may have.
Thank you very much. Any questions? Garrett?
OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by ED staff.
Thank you, Garrett. Mary, do we have anyone signed in on this item?
No one signed in on this one.
All right. Well, I'm grateful to those who donated so our staff was able to attend these various training events. I've reviewed the donations and I'm ready to approve the resolution acknowledging the acceptance of the donations in the report. Commissioner Gonzalez?
Same.
All right. I move that we approve the issuance of a resolution acknowledging the executive director's acceptance of the gifts and donations contained in the TCEQ inter-office memorandum to the commissioners filed in docket number 2025-1683-MIS.
Second?
All those in favor say aye.
Aye.
Motion passes. Thank you. This brings us to the enforcement docket.
Okay, the enforcement docket are items 6 through 28, and the Office of General Counsel remanded item 22 yesterday at the request of the ED. The Executive Director's staff is here to present these matters.
Good morning, Chairwoman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Settermeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 21 and 23 through 28. The total assessed administrative penalties are $1,885,118, with $133,225 deferred, $915,858 applied towards supplemental environmental projects, and $836,035 to the general revenue. We respectfully request approval of these items, and we are available to answer any questions you may have.
Thank you. Any questions for ED staff? All right. Do we have anyone signed in on these items, Mary?
On items 6 and 15, there are individuals who are available to answer questions but didn't ask to address the commission.
Do you have any questions for? Okay. All right. Garrett?
OPIC has reviewed each of these enforcement items, and with the exception of remanded item 22, we support adoption of all the orders presented by ED staff.
Thank you, Garrett. I've reviewed these orders, and I'm prepared to move forward with them. As always, I'd like to thank staff of the Enforcement and Litigation Divisions for all their work that goes into presenting these orders for our approval. Commissioner Gonzalez, thoughts?
No, I'm good to go.
Yep. Do you have a motion?
I move that we adopt items 6 through 21 and 23 through 28 as recommended today by the Executive Director.
I second. All those in favor say aye.
Aye.
The motion passes. Thank you, ladies. Let's move on to the rules matter.
Item 29 is the consideration of the adoption of amended 30 Texas Administrative Code 60.1 and 60.2 regarding compliance history. The Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioner, General Counsel, and Public Interest Counsel. For the record, I am Amy Settermeyer with the Enforcement Division. With me is Krista Clement of the Enforcement Division and Misty James from the Litigation Division. This adopted rulemaking implements the changes required by Texas Water Code Section 5.754, Classification and Use of Compliance History, as amended by Senate Bill 1397 from the 88th Texas Legislative Session. Specifically, when determining repeat violator status, the statute now requires the consideration of moderate and minor violations in addition to the previously considered major violations. This adopted rulemaking also addresses legislative direction following the agency's sunset review to increase the frequency of the compliance history calculation and to evaluate and update the compliance history formula to ensure it adequately considers the complexity of facilities when calculating their compliance history ratings. The proposed rules were published in the July 25th, 2025 issue of the Texas Register. A public hearing was held on August 18th, 2025, and the public comment period closed on August 25th, 2025. The rule team received public comments and made the following substantive change based on those comments. adopted 60.2F3, changes the proposed repeat violation point thresholds based on complexity points to determine repeat violator classifications. The proposed rule established repeat violator thresholds based on 2 complexity groups. A rule language update was made for adoption to increase the number of complexity categories from 2 to 5 with different repeat violator point thresholds for each group. Staff respectfully recommends adoption of this rulemaking to Chapter 60 compliance history. Additionally, staff requests authorization to make non-substantive provisions necessary to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, Amy. Any questions for ED staff? Nope. Is anyone signed in on this item?
Yes, we have one person signed in, Catherine Guerra.
Catherine, are you online?
Good morning, Commissioners. Can you hear me?
Yes.
I'm Catherine Guerra with Public Citizens Texas Office. Public Citizen is a nonprofit consumer advocacy organization with over 1 million members and supporters that champions public interest in the halls of power. First, this rule revision, which includes minor and moderate violations in the repeat violator criteria, closes a dangerous loophole that has allowed chronic polluters to avoid the repeat violator designation and meaningful consequences. Major violations, which account for just 11% of the total violations in 2025, were the only category previously considered in compliance histories. But we were disappointed that despite numerous environmental advocacy organizations providing relevant comments that would have further strengthened this rule revision and aligned it with the Sunset Advisory Commission's recommendation, the agency rejected or refuted every comment they provided. Instead, the agency has amended the rule from its original draft to acquiesce to industry, which has proposed to make it easier to avoid repeat violator status. We disagree with the proposed revision, and we're doing so after the comment period ended without further opportunity for the public to have comments considered about this revision in any meaningful way. Regarding the exclusion of NOVs from consideration of the repeat violator formula for the full 5-year period, I want to reiterate that non-compliance is what the compliance history is intended to reflect, whether it is resolved with or without enforcement action. If the agency only intends to consider violations from final commission actions after due process, as stated in the response to comments, then the agency must also change its longstanding enforcement policy of not sending entities to enforcement when they are already in enforcement for that same violation, essentially avoiding repeat violator designation. The Sunset Advisory Commission Recommendation 2.1 states, direct TCEQ to review and update the agency's compliance history rating formula to ensure it accurately reflects a regulated entity's record of violations. It goes on to say TCEQ should specifically consider major, moderate, and repeat occurrences of the same minor violations when calculating compliance history ratings. This recommendation is not that the TCEQ consider only enforcement, which is what this rulemaking seeks to primarily base compliance history on. The Sunset Commission quantified the percentage of unclassified regulated entities during FY 2021 as 89%. More recently, that percentage rose to 90%. And during the question and answer session of the August 18th, 2025 public hearing, TCEQ staff responded that the agency has no intention of reducing the number of uninspected or unclassified entities because the Sunset Commission did not recommend and the legislature did not mandate that it do so. The lack of a mandate to adopt procedures that meet the goal of the TCEQ and the Sunset Commission does not constitute a prohibition on doing so. The compliance history program cannot function as intended to make appropriate regulatory decisions based on compliance status unless the TCEQ proactively and directly addresses the volume of facilities listed as unclassified. Thank you.
Thank you, Ms. Guerra. Any questions or comments for Ms. Guerra? No. OPIC?
Yes, thank you, and good morning again, Chairwoman, Commissioner, General Counsel, and the Executive Director's attorney and staff. I'm Sheldon Wayne on behalf of the Office of Public Interest Counsel, just for the record. Our office has reviewed this rulemaking, and we agree that it is necessary to implement statutory requirements contained in SB 1397, referred to as the Sunset Bill, as well as recommendations adopted by the Sunset Advisory Commission. We are supportive of these changes and believe that they will help to foster compliance among regulated entities, primarily by requiring moderate permit and minor violations to be considered when determining whether an entity qualifies as a repeat violator. We also find that the five-tiered approach with complexity points used to establish the point thresholds for repeat violator status is both reasonable and defensible. It recognizes that because they are often subject to self-reporting requirements, more complex facilities may have violations discovered more frequently, whereas less complex facilities are only subject to violations uncovered through investigations. Finally, the increase to semi-annual updates of an entity's compliance history rating will make more current compliance history information available to the Commission to use in its processes, such as during consideration of permit amendments and revocations for unsatisfactory performers. Therefore, OPIC supports adoption. Thank you, and I'm available for questions.
Thank you, Sheldon. Well, colleagues, after reviewing the, colleague, after reviewing the comments submitted during the comment period, I agree with this rulemaking appropriately implements the changes to Texas Water Code Section 5.754 made by the 88th Texas Legislature in Senate Bill 1397 and addresses the concerns of the Sunset Advisory Commission regarding repeat offender status, comparing facilities of similar complexity, and establishing a semi-annual compliance history evaluation. Regarding the changes after proposal, I agree that the expansion of the complexity categories from 2 to 5 when determining repeat violator status better ensures that regulated entities of different complexities are treated equitably when determining compliance history ratings. So I would adopt the amended rules as recommended by the ED. And I would also like to note and thank staff. This was a big lift for staff to do. They worked with all of our stakeholders to make sure that we got these rules right, and I really appreciate it. Katerina?
Well, just as has been noted extensively, this is part of our sunset implementation, so we've made some really significant progress on that. I'm glad about all the work. I mean, this is a tremendous achievement that this rule. And, you know, like everyone's a little bit happy, a little bit sad. So I think we got in a good place with the bill or with the legislation. I appreciate the staff staying true to the legislative direction. I was, it's one of my things. And so I think y'all did a good job on the rule and look forward to seeing it in action. So thank you very much. It was a heavy lift and y'all did a great job.
Yes, I think they threaded that needle beautifully. Yeah. I would move that we adopt the amendments to 30 Texas Administrative Code Sections 60.1 and 60.2 as recommended by the Executive Director.
A second?
All those in favor say aye.
Aye.
Aye. Motion passes. Thank y'all. Let's move on to the next rule. Item 30.
Item number 30 is the consideration of the publication of and hearing on proposed amendments to 30 Texas Administrative Code Chapter 293 regarding water districts. And the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Cindy Hooper with the Water Availability Division, and with me today is Kayla Murray with the Environmental Law Division. This rulemaking proposal will modify 30 TAC Section 293.23 and will implement House Bill 2080, passed during the 89th Texas Legislature's regular session. The bill amended Section 36.3011 of the Texas Water Code regarding petitions for inquiry into the actions of a groundwater conservation district. The bill establishes additional requirements related to a review panel approved by the Commission under this section, and this rulemaking proposal implements these changes. A public hearing will be offered on this proposal in Austin on February 24th, 2026. It will be available both in person and virtually. Staff respectfully recommends approval to propose the publication of and hearing on Title 30, Texas Administrative Code, Section 293.23. Staff also respectfully requests permission to make non-substantive changes to comply with Texas Register requirements. Thank you, and we're available for questions.
Thank you very much. Mary, do we have anyone signed in on this?
We have a person who signed in but indicated that they don't want to address the commission, so their presence will be noted for the record.
Right. Thank you. OPIC?
Hi, yes, good morning again. Chairwoman, Commissioner, General Counsel, and the Executive Director, Attorney, and staff. I'm Sheldon Wayne on behalf of OPIC. Our office is participating in this rulemaking and agrees with the Executive Director that it should proceed forward for publication and the taking of public comment. This proposal is necessary to implement statute and addresses issues identified by the TCEQ Sunset Self-Evaluation Report and the Priority Groundwater Management Areas and Groundwater Conservation Districts report to the 89th Legislature. We note that a public involvement plan will be required. TCEQ will develop a plain language summary, and alternative language requirements must be followed as well. Furthermore, OPIC is supportive of the substance of this rulemaking. We observe that by providing reimbursement for the expenses incurred by the panel and both technical and legal support, these proposed rules will will encourage recruitment of and assist the review panel once it's formed, ultimately helping TCEQ fulfill its statutory directive of providing oversight of groundwater conservation districts. Thank you, and I'm available for questions.
Thank you very much. Any questions for OPIC? Nope. All right. This rulemaking is an important step towards implementing House Bill 2080, and I appreciate staff's work on amending these rules to implement this legislation. I believe it stays very true to the legislation that was passed. I'm looking forward to hearing what the public has to say about the proposed changes to the rules and recommend we move forward with the publication of the rules package. Katarina? All right. Do I have a motion?
I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 293, as recommended by the Executive Director.
I second. All those in favor say aye. Aye. Thank you. All right. Moving on to public comment.
Yes, that's correct. So item 31 is our public comment session, and the commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112. Note that they may hear anything except for comments on pending permit matters or other contested cases, which are subject to a prohibition found in the Texas Government Code, Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given is limited to statements of specific factual response and recitation of existing policy. And with that, we'll move on to the commenters, and we have one commenter today, Errol Summerlin, and he's virtual.
Mr. Summerlin?
Can you hear me?
We can hear you.
Oh, great. It's a little different scene on my screens here. Well, my name is Errol Summerlin. I currently reside in the state of Maryland for family medical reasons, but reside in Portland, Texas for 40 years and am co-founder of CAPE, the Coastal Alliance to Protect Our Environment. I'd like to talk about air and groundwater this morning and how we regulate them so differently. Just an observation from someone who knows just enough to get himself into trouble. With the exception of maybe 24 counties in the state, drilling wells to take groundwater is managed by groundwater districts. These districts grant permits to allow you to use the water for most anything you want to use it for. So you can have hundreds of wells drilled in a defined area. But the groundwater district does monitor water levels. If you come in wanting to extract large volumes of water, the district has a responsibility to protect that supply for all users. And if your request would drain the area or otherwise affect the availability of water from your neighbors, they say, no, you can't pull that much and deny the permit. In those counties with no groundwater district, it's an old-fashioned range war between landowners. But when it comes to the air we breathe, the state takes a different approach. A large industrial facility can obtain an air permit that the TCEQ determines satisfies clean air standards. That same facility can go down a few hundred yards and build another facility that emits the same number of pollutants as the first and gets a permit. And they do it again and again, separated by only a couple of hundred yards. So let's say each permit allows 1 ton of PM 2.5. Within a half mile, you can have 4 or more of these emitting upwards of 5 tons. And it goes on and on for miles in some locations in Texas. So you can't take groundwater if it depletes the supply of your neighbors, but you can emit tons of pollutants into the air, regardless of how it might impact the air that your neighbors breathe. The primary difference between the two appears to be ownership. The owner of the surface generally owns the groundwater beneath, and protecting property interests is one of the most important provisions in the Texas Constitution. But the air we breathe is not a property interest. I don't own the column of air above my property. It's free for the taking, and that's wrong. If we don't own the air, why is certain airspace protected from intrusion? You can't fly a drone over protected airspace above another's property. Industry in particular is very sensitive to that. If I can stop a drone, why can't I stop my neighbor's pollutants from intrusion into my airspace? I shouldn't have to prove anything other than the quality of the air I breathe is diminished by the incessant stream of pollutants into my space.
3 minutes.
My groundwater is protected from depletion. The air I breathe when sitting on the back porch should be protected in the same manner. Thank you very much for your time today.
Thank you, Errol. Anyone else?
Nope.
Okay. Is there anyone else who wishes to address the commission at this time? All right. With that, this commission will meet in closed session.
Okay, the commission will meet in closed session in room 4222, building F at 10:45. Sound good? Earlier?
Let's do 11.
Okay, at 11 a.m. as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items 32 through 35 as posted and noticed.
All right. Thank you. This meeting stands in recess.
The commission met in room 4222 of Building F for closed session from 11:09 a.m. until 11:28 a.m. on item numbers 32 through 34, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned. The time is 11:44.